We have a very important minute entry in the Lori Daybell case. The court has received and reviewed the following: defendant's motion for new trial with attached exhibits filed June 23rd, 2025, state's response to motion for new trial filed June 30th, 2025, defendant's reply to state's response to defendant's motion for new trial filed July 10th, 2025. The defendant's motion argues three separate areas she believes warrants a new trial. First, the defendant argues she suffered a due process violation by being made to proceed to trial when she was too sick to do so, and the court further violated her rights by seeking an objective determination of the extent of her illness. So they're saying that what Lori was saying is she was sick, and actually verifying she's sick is another violation of her rights. The defendant's motion for new trial raises new allegations regarding the extent of her illness that were not part of the record during the course of the trial. This issue was resolved during trial, and the court has not been presented with any new, reliable evidence indicating the defendant's illness negatively impacted her ability to proceed with trial. The record and observations of the defendant's physical appearance, questioning of witnesses, and arguments to the court and jury all evidence the opposite, that she was able to proceed to trial. She couldn't even fake it. The second point raised by the defendant is an allegation that the court lacked impartiality because of the court's evidentiary rulings. The defendant first argues that evidence impartiality exists because the court sustained two hearsay objections from the state when the defendant attempted to cross-examine police officers about statements made by neighbors. The defendant's own motion establishes these are the very definition of hearsay statements. When ruling on evidentiary issues, there is no rule or case law that requires the court to allow a response from the opposing side. The defendant argues in her motion that one of the statements was not offered for the truth of the matter asserted, different description of vehicle, but for the effect on listener. The defendant never articulates what effect on the listener the statement would have had. The defendant also never articulates how, if that statement came into evidence and it was not actually offered for the truth of the matter asserted, which appears to be the only reason the defendant wanted the statement entered into evidence, it would have changed the outcome of the trial. The defendant then argues she was unable to admit several exhibits. She could not effectively cross-examine witnesses regarding Melanie Boudreau. These are, again, basic evidentiary issues were ruled on during trial. Just because the defendant does not agree with the court's ruling does not mean she is entitled to a new trial. The defendant never articulates how or why the court's rulings were wrong or how the rulings constitute a due process violation. Basically, her argument was it hurt her feelings and she doesn't like the way it went. Didn't actually back it up with any laws, meaning that they did something wrong. The third area of argument is titled Abuse of Discretion. She argues, one, she was entitled to a Rule 13.5 hearing on aggravators. So this is where Lori didn't want to actually have to listen to the aggravating factor portion because they can talk about how terrible a person she is in the presence of the jury. That's the one she stipulated to, and she was trying everything she could to deny it, delay it, get a hearing. Obviously, it didn't work. 2. The court did not release the jury from admonition on the record, which I don't think they did correctly, at least. The court erred when allowing scientific evidence regarding GSR and DNA to be presented to the jury. And 4, she was denied the right to confront witness LeChick. The first 2 points in no way have anything to do with how the jury viewed the evidence or deliberated, therefore would not have a basis for a new trial. I've said that before with the admonition thing. It doesn't make sense how that would be a new trial. They weren't involved in the process after that point anyway. The court ruled on the 13.5 request, which is essentially moot given the fact that the defendant chose to stipulate to the aggravators rather than have the evidence be determined by the jury. She screwed up. She should have been willing to sit with it. The defendant is correct. The jury was not released from the admonition on the record, but has no rule or case law requiring the jury be released from admonition on the record. Okay, didn't know that. The court did go back to the jury room and release the jurors immediately following the defendant's admission to the aggravating factors. Again, the defendant never articulates a reason why this would entitle her to a new trial. So I think basically she got the wrong impression because they did bring them back for the first trial, where she also had the same argument about the aggravating factors. The defendant's argument about DNA and GSR evidence seems to be more of a chain of custody or foundation argument rather than substantive argument about the reliability of the evidence. The defendant's reply for the first time mentioned the evidence being junk science, but she never presents any actual evidence or authority to establish the evidence was not reliable. That is very brave. Now, Lori Daybell is going to be the one to let us all know that DNA and GSR are junk science. Wow. Moreover, if there were questions as to his reliability, a competent and thorough cross-examination could have revealed those issues for the jury to consider. Listen. Lori is not competent. It is unfair for the judge to think she can do a competent cross-examination. We watched the trial, right? Although the state chose not to call the person who actually collected the evidence a chick, the state satisfied the foundation requirements to admit the evidence through Detective Pillar, who was present during the collection of the evidence. The reply also alleges hearsay statements from the chick were allowed into evidence, but does not state what those hearsay statements were. It is the court's recollection that no statements of a chick were offered or admitted. Finally, the court in no way precluded the defense from investigating this witness. As the defendant alleges, in fact, the defendant could have subpoenaed and called this witness if she wanted to question this witness. The defendant fails to establish any due process violation which would warrant a new trial in this matter. It is ordered denying motion for new trial. So with that being said, verdict 25th. Maybe. I say maybe because is she going to fake illness, cause problems? Is she going, like, the thing is, she so far in Arizona has gotten to a void where they can go and dig into her and what she really is without having to put on a mask to hide Idaho. If you didn't watch my last video, I highly recommend it. They go into what she did to the children. They can talk about that now, and Lori doesn't want to hear it. I would not be shocked. I would not be shocked at all if Lori does something to try to get out of court on Friday, even if it's causing a scene or something, so they have to remove her just so she doesn't have to sit and listen to what people want to tell her and people talk about her, because she's going to be very, very upset and angry she doesn't get the final say. So this is an update. A lot of people would say, obviously, this one was coming. We all knew this one was coming. But just for completeness, we need to talk about it. And I just want to talk about how there's still time for Friday. She can try something.